Well, Sam, it's been a while.
It has been a while.
I think it's something like 8 months.
Well, you would know, 'cause, you've kept track of these things.
So we should apologise, I suppose. There's been a break in the Planning Pulse, not for any particular reason. A lot going on, I guess, but for one reason or another, we've just not decided to sit down and record an episode. But
No.
here we are.
And we've always wanted to.
Yeah.
We've always got things that we've wanted to feed back.
Yeah.
But yeah, mixture of things and time and who's around.
That sounds like a load of excuses. So
It
let's not
does,
go there.
yeah.
All right, here we are. We're back. So this particular episode, I think, is warranted because there's quite a big change on the horizon, isn't there?
Yep. And we've just dealt with it at a local level today as well. So we'll let everyone know what that is about.
Yeah. So this morning there was the full council decision, which has authorised a change to the constitution. So the constitution being, in effect, the rule book, right, on how everything that we do at the council.
Yeah, how the council operates, the rules by which we do it.
Yeah, and that includes the framework of how and where we process planning applications.
Yeah.
And that's come about because government is trailed and consulted on what's called a National Scheme of Delegation, which, as a consultation item, we submitted representations as a district council, and we can include a link to our comment. We objected.
We did. I mean, do you want to start a little bit before then, explaining what the National Scheme of Delegation is?
Yeah, go on. Okay, let's go for it.
So for those in the know and those that aren't, the government for a little while have been thinking about the different ways in which development is brought forward across the country. It shouldn't be a surprise to most people that there has been lots of talk about how development is expedited, how we can build more homes, etc. And one of the things, and it is only one of the things, because there's lots of different things the government have been considering, is whether or not the way in which local authorities make decisions on their planning applications needed to change. Government get lobbied by lots of different people, and for whatever reason, they decided that sometimes the way in which local authorities determine their applications via their planning committees was a potential issue in relation to more housing coming forward.
You were going to say blocker.
Well, yeah, I wasn't. Consider that was a bee forming in my mouth. And so, yeah, they did a consultation, which we did object to, about the introduction of something called a National Scheme of Delegation.
Yeah.
So we have a scheme of delegation in our constitution, the document that Stacey just referred to.
Yeah.
But this was government intervening and saying, well, we think that this can be standardised across the country. And here is a set of rules by which we think planning applications can be decided while still giving, in their view, the means by which local authorities can still kind of have a say in
how they process
those cases.
We can come to that bit in a second, but I suppose we should further explain that although it's a national scheme of delegation and is, dare I say it, been imposed from on high, there is nonetheless a requirement to adjust the local rule book, the local constitution, to absorb that national scheme of delegation. And that's what today's full council report was all about, albeit we should stress as a minor point, or those that are really interested can go and look at it. The report that went today was the bare minimum, so the minimum necessary to get us ready and safe and legal for the commencement date. Now, that isn't for a little while, is it? It's across the summer. Some that have tracked this will spot that initially government were talking about the end of September.
For the introduction of the new scheme, they pushed it back
to the end of October.
But because of how our own processes work, we realised that in order to make sure that, like Stacey mentioned, that we were legally sound, by the time that it came around, that we've done, in the first instance, the minimum required. And this was a full council that was timetabled already, because the next one is not close to when September. It's actually being introduced. So we thought, well, in the first instance, let's do this. Let's get the minimum done so that
we're safe and legal.
We're safe and legal.
There isn't an operational impact.
Just on the off chance that we can't then also get other bits sorted by the time September comes around, that at least we can operate within the new rules. So we've had full council today.
And members resolved to grant. I think under duress, grumpy. Not a lot of discussion. However, the discussion separately. We've debated with members at Cabinet Advisory Group. We've done mandatory members planning training this year and have trailed this issue because it's long since been coming.
Yeah, so that was an opportunity for us to discuss it with them, and everyone was quite open and candid when we spoke to them about it. So when you say they were grumpy,
well,
not that we should speak on behalf of members.
That's true.
But we do understand where they're coming from.
It's a frustration.
It's a frustration. It's a top-down approach to controlling how development comes forward, and lots of people have got different views about why that's an issue, be it impacts on democracy, or how local decision making is being taken away, and just how members see their own roles generally
role in the process.
What is their role if they're not otherwise there sitting on committees making decisions on behalf of their communities.
So that probably brings us on to what it actually looks like and feels like, as opposed to what perhaps people are used to seeing, certainly at the Wealden level. So very quickly, as a canter through. So at the moment, applications can be reserved for committee within a time period from the receipt of application. So members can escalate into committee at that early point, as long as they've got planning reasons. And then there's a second stage where later in the process of assessing a planning application, depending upon how it's been received, comments that have been received, including representations from parish and town council, if the outcome of the officer assessment at that point is at odds with
those representations,
we write a report, and then the discretion to accept that report or escalate it into committee rests with the local planning member. That's been in place forever here, certainly as long as I can remember.
Even when we adopted our current constitution, which was only last year, it didn't really change that approach significantly.
That's right.
It tweaked some different aspects, but
So that's going pretty much wholesale. And the headline on that is there's no automatic right to refer in. And also there is an abolition nationally, not just in Wealden, of officers having to liaise with a local member to test that discretion point, to test that, is it okay to proceed under delegation, or do you want this to come into committee? A bit more of a further discussion about planning reasons for that escalation. So that's going. And in its place is two categories of application types called Schedule 1 and Schedule 2.
So our local scheme goes, a planning application is submitted, and then when it gets to making a decision about whether it goes to committee, this is what the National Scheme of Delegation sets out. So first of all, it categorises the applications. So 1 and 2.
Schedule 1 and 2. And the application types are defined by government. So there's a prescribed list. We can include a link if that's helpful of what Schedule 1 applications are. And really it's kind of run-of-the-mill cases, shall we say. So it's like householder applications, it's condition discharges, it's adverts, all those sorts of bread and butter applications, if that's the right way to put it, which I know they're important to lots of people that make those applications, but they're the ones that they're the churn applications. We get an awful lot of them, thousands per year. Those are always delegated, and they will be anywhere in the country, not just in Wealden.
No, and your point about they're important to some people, whoever it may be involved with those, be it the person that submitted them or people that might live nearby to that. And you may well have seen that because they're important to you, those types of applications have been at our planning committees in the past. We've had lots of instances in which, like a householder application, for example, has been brought to planning committee, and that would be because the application was potentially being recommended for refusal, and that was a frustration to the person that had applied. And in reviewing the matter, the local member thought it was worthy of consideration at committee and gave planning reasons why it should be there. But equally, it could be being approved, and local residents might be concerned about it. A neighbour might be concerned about it because of the impact it might have on them. And again, the local ward member considering it thought that's worthy of being a planning committee. And then that's why such items have been there before. But that's one of the clear distinctions, that applications of that nature
are now deemed by government to not
be significant enough
to justify committee time.
To justify committee, yeah.
So those are not our rules; those are government rules, and they apply everywhere in the country.
So then we've got Schedule 2
cases.
applications.
Yeah, and these are slightly different, albeit there is a presumption that they are delegated, but there is what's called a gateway test.
Yep.
So this gateway test is an assessment of whether subject case it meets a set criteria to justify being taken up to committee. Now, that involves a designated officer, which is not yet defined here at Wealden.
I was going to say, do we actually know what it is?
No, we don't.
We do. We do.
Well, we think we know.
We know what the regs say.
We know what the regs say. Yeah, I think it will be us too.
Yeah.
But we need to do work on that, obviously, and quite quickly, ready for October. And there then needs to be a designated councillor. The regulations refer to that person as most likely being the chair of the relevant planning committee.
So just to be clear, that's because when you have an application that's on this Schedule 2 then, so possibly could go to planning committee, the assumption being that it actually is delegated, but if it goes through this test, it could make its way to planning committee.
It could make its way to committee.
You've got to have 2 people in place that help make that assessment.
Yeah.
So a lead officer
and a
lead member.
And just very quickly, the law now requires that assessment is documented and recorded and is published as a matter of public record. So we've been thinking about how we do that, and we will obviously comply with that. And then a little bit more about, although it's hinted at in the regulations, but the clear inference is that we've got a slightly different duty now to how we publicise applications. I think making it clear at the relevant point that they're either Schedule 1 or Schedule 2 cases. Although I'm slightly nervous about that, because the minute you say that something's Schedule 1, you're potentially accused of deterring representations, and that's not the point of the regulations and the change, although we'll come back to consultation in just a second. So I was going with that. So we've got to document it. We've got to publicise that.
Yeah.
And of course, we've not done that, but you can look at what the government sets out as the criteria for that assessment. Now, this is a sort of sting in the tail, and again, it's not of our making, but again, the presumption is that delegation.
Yeah. Schedule
2 is that there's the potential to escalate to committee, providing the gateway is met, but it requires agreement of both parties. So lead officer, lead member must agree.
Yeah.
And if any of the parties disagree, then the regulations stipulate that the subject case is delegated.
Yeah. So do we know enough to explain about what the test is?
So no, we don't yet, other than we can
There's a headline.
There's a headline. So there's headline criteria, what the government sets out, but there's a discretionary element, which is up to each council to wrap a bit more around that criteria. We've not done that work, and there's a reason for that. As you said a moment ago, we've gone early to our July 4 council because of the short period of time when we need to be safe and legal and ready to go at the end of October. What the full council report explained today was that we're going to do some further work on this.
And that's the point, we need to do some further work, don't we? Because this headline aspect is matters can be referred into a planning committee if they relate to significant environmental, social or economic matters, subject to a criteria or a way in which we set out how we would assess that in those case-by-case instances.
So we've got to publish that. We've got to think about that. We've got to publish that. I think we will be involving elected members in that. So work still to be done. I think we should stress, though, not to be kind of difficult about this, but we need to make it clear that that's not a substitute for the referral in process or the current ability for members to call cases in. And government are clear about that.
It's new, it's different. We have to operate it in this way that it's set out.
So that's it, really. That's the long and short of it. And it's a big change. It really is. And I know there's an awful lot of, angst concern about it being anti-democratic, and to a certain extent we would agree. The objection that we put into government at the time when they were consulting on this proposed change made all of those points, and some in terms of additional arguments why this was considered to be a retrograde step. I mean, the power of a veto resting with any one person of the two designated people is
quite an interesting dynamic, doesn't it? I think.
Yeah, it does. Yeah. And elsewhere, if you look online, there are different forums and different groups that talk about this, and I think it's accepted that a lot of people are saying, you've got to put your tin hat on. There's a lot of pressure or rather weight on your shoulders. So that's, I guess, it is what it is, right? Yeah. There's a consistency point, which I think is really quite important. So you're swapping out a well-known, tried and tested and known route where applications could be escalated into committee, and we're putting in a whole new procedure with, let's face it, discretion and judgment, and that, if it isn't handled correctly, is a problem for consistency, which is one of the reasons why we do need to do this work, and we need to publish that so people know what we're measuring and testing the gateway.
Well, it's also why ultimately we end up having to publish the reasons why it was delegated or not in accordance with the new process, isn't it? Because it will be there in black and white. And I suppose an element of this is, over time, it will speak for itself, won't it, in terms of whether or not there is that consistency, or are there issues, and if they are, how do we as a local authority deal with them? Let alone, how does the government review it if they need to, or how do the public feel about it? So we just thought this would be a good instance to re-establish the pulse, do it in video form, but put this out there. Because what we're otherwise going to do is do some comms about it. We'll have some information on our website about it, and it will be both some basic information, because we will be having to do this by the time October comes around.
That's right.
As well as this other stuff that you've mentioned about, actually how we will apply the gateway tests and all that kind of stuff. But so this was a good forum to kind of
definitely
introduce
a good forum to do it, and to say, we've been away, but we're back. Or we haven't been away, we haven't been recording an episode of The Pulse. I guess one final thing, which I think is probably going to be a burning question in people's minds, which is what's happening to live casework. So these changes aren't going to be stood up until the end of October. They're not live today, because the full council's taken a decision. So when we're ready to go, well, we've got more work to do, but we'll be ready to go at the end of October. So at that point, though, all live undetermined cases will be subject to the new rules.
It won't just apply to stuff that's coming in from then. It's anything that's undecided at that point in time.
Which I think is going to be important. We're going to need. We'll need to trail that change, so that it isn't a really kind of sharp shock on the day. So we will be doing that as well.
Yeah, and I suppose we'll have to think about, won't we, whether or not, in addition to anything we put on our website, because we would have sent out types of notifications, be it to members or applicants or interested parties. We'll have to make a decision about whether or not we notify people, I think, on those individual cases or in some kind of specific area on the website about what we have at that point in time. And by the way,
it's a really good point.
It's changed in terms of how it might move forward with in terms of decision making. I think it's particularly important. Fine, yes, to local residents, but because individuals might be harder to reach, we definitely will be contacting ward members, town and parish councils,
absolutely,
to tell them about
the
change as we get closer to it, but also when we have to implement it. So that everyone knows what's happening.
And I guess the final point really is just around that engagement and consultation. I've already alluded to it in terms of an actual change, but this is absolutely not, well, it isn't in my mind, or welcome your views, and I think I know.
Shall I say the opposite?
Yeah, you say the opposite. Just that whole anti-democratic, what's the point? The system's against everybody. But that kind of argument, on the one hand, you can understand why people would say that, but we'll call them the much larger strategic cases are carved out of this process, so they would be committee items. You know, so the allocation in a plan of hundreds of houses, or, you know, a greenfield site that comes in that's hundreds of houses or whatever it may be, that there's no suggestion that that would be dealt with at officer level. And it's really important. We say this all the time, and I think even more so in the new process. Local people have got their ear to the ground. They know the beat. They know their patch. They know their areas. We work here. We think we know it, but local people, they do add value, and it's really important that people continue to make representations.
Definitely.
I know there's this view that they're not read. They are. I know there's the view
that
we ignore them, but absolutely we don't. You know, the best schemes, for me anyway, the best schemes are the ones where people will say, look, I don't want it, and I'm objecting to this, but if it's going to go ahead, the access should be over there, or that tree is really important, or don't have anything beyond that point because there's a view through there, or something. That local knowledge is a really important building block to creating really important and sustainable places. Yeah. So please, really, if you take one thing away from this, it's continue to make representations, because those are essential, and this is not a don't bother commenting.
Because they still influence the decision making.
Yeah, absolutely.
As much as what you just set out in
waffled
terms of
on about,
or in terms of how sometimes people might perceive the process. But
absolutely,
they definitely are useful still.
All right, well, that's it for our kind of pulse that's back. A couple of other things. We will continue these. I think they'll take 2 formats. You'll have a slightly longer one, a bit like this, if there's something meaty to talk about.
I didn't realise this was going to be the approach to it.
Well,
so we're going to do like a short one and a long one.
Well, I think there could be short ones, couldn't there? There could be if we haven't got something really quite topical, it could just be a much shorter update about a recent case or an appeal, and then slightly longer ones when we've got something more to talk about. And then finally, in terms of what we're doing, is don't forget the Ask the Development Manager. Still a forum that's available online. It was really popular, and we received lots of queries, and we built that library of responses, which I think people regarded as helpful and useful. I think people have forgotten.
Yeah, so we can include a link to that, can't we, in the notes that go with this? Plus those other links, those other things that you mentioned.
We will.
So we'll definitely do that. Welcome back as well to anybody that's watching, and leave a comment actually about this format, and as ever, because we used to say this before in other episodes, if there's things that you want us to talk about, then
tell us.
We're all up for ideas and suggestions too, so definitely put that in a comment too.
If you've got something negative to say, then don't leave that comment.
There's other forums for that.
Right, thanks very much.